Morning, everyone. Um, we are supposed to have a group of international students from UNC. I think the group is 7 or 8. Um, it appears they're running late, and they may enter during the argument, but I don't think it'll be terribly disruptive. I think they'll just come in the back door. So I just want council to be aware of that. Our first case is In Re LL, and we will hear from the appellant.
Good morning, Mr. Chief Justice and Associate Justices. May it please the Court. Nathan Wilson, here on behalf of Liam's foster parents, Major and Mrs. Hall. I'm joined at council table by my co-counsel, Morgan Reese, as well as by Matthew Wunsch, who represents Liam's guardian ad litem. I'll be delivering the majority of the argument, and then Mr. Wunsch will present the guardian ad litem's position. We request 5 minutes for rebuttal. Thank you. At issue before this court is whether the trial court's order complied with 3 provisions of the Juvenile Code, 906.1, 906.2, and 903. And in my argument today, I'll proceed through each of those statutes in turn and discuss why there was no error. But before I do, I want to start with the portions of the trial court's order that the Court of Appeals affirmed and which Respondent did not appeal from, because those are critical in understanding why there was no error below. Specifically, the Court of Appeals affirmed that when Liam was less than 6 weeks old, he was hospitalized with a severely bruised skull, numerous broken bones in various stages of healing, and he weighed less than the day he was born. The Court of Appeals further affirmed that Respondent was responsible for these injuries and that as a result of them, Liam will be dealing with significant medical issues for the rest of his life. These findings, together with the rest of the trial court's order, show why there is no error under any of the challenged statutory provisions. Now, the first provision at issue is 906.1. And before we get into the application, I'd like to say a little bit about the opportunity this court has to provide guidance to the Court of Appeals. Because 906.1e applies at every single permanency planning hearing where the juvenile is not placed with a parent. That means that for TPR proceedings, permanent custody proceedings, these proceedings that come up before the Court of Appeals, the appealing party will be able to challenge it under 906.1e. And so this court has the opportunity to provide guidance to the Court of Appeals as an error-correcting court in how it should approach such a challenge. So when an appellant challenges a permanency planning order for failing to make written findings under 906.1e, the statute says that written findings are only required if they are relevant. In other words, the Court of Appeals, as an error correction court, can begin its analysis by determining whether a specific factor under E is relevant, and if it's not, then there can be no error. And that analysis should have applied here. Specifically, Respondent has challenged whether the trial court should have made a finding under 906.1e1, whether it's possible for the juvenile to be placed with a parent within the next 6 months, and if not, why such placement is not in the juvenile's best interests. Now, at the proceeding below, this proceeding was happening after the permanent plan, the primary permanent plan, had been changed to custody with a court-approved caretaker. So there was actually not any argument about whether Liam could be reunited with Respondent in the next 6 months. Instead, what was being disputed was whether Liam should go to Mr. Westbury, the paternal grandfather, or to the Halls. And in CJC, which interpreted similar language in 7B1110 about factors that are relevant, this court's analysis was we don't look back through the evidence to see if on appeal we can find some conflict and make that relevant. Instead, we look at whether it was actually argued to the trial court below and disputed before the trial court, and thus the trial court was aware it was an issue that needed to be addressed. And in this case, there was no argument about whether Respondent could be reunited with Liam in the next 6 months. If you look at what her own attorney said on page 128 in closing arguments, she said we should allow mom to eventually work towards a permanent plan of reunification. So again, the permanent plan at the time wasn't even reunification, so the permanent plan would have had to be changed at a future permanency planning hearing before we started back on the track toward reunification. That's why this was not an issue, and because it wasn't an issue, it wasn't so relevant that the trial court erred by failing to address it. However, if this court does find that it is relevant under CJC and other cases, then there are findings in the trial court order that goes directly to it. Specifically, in the preceding 3 orders, the trial court had found that respondent could not be reunited with Liam in the next 6 months because she had failed to plausibly explain the cause of his injuries. And once again, if you look at the order in this case, page 284, paragraph 7.8, the trial court says that respondent has failed to plausibly explain the cause of Liam's injuries. Respondent has not appealed from any of those prior decisions which said this is why Liam can't be reunited with respondent in the next 6 months. We have a finding that's exactly on point, and just because it does not include the statutory language does not mean we are reverse under it. This court has recognized that in numerous cases. It addressed the substance of the factor, and that's all that's required. So there was no reversible error under 906.1. Moving on to 906.2, I'd like to first start with B and D4. And I get that there's some textual difference between the twos, and there might be some cases where that textual difference matters. But in a situation like this where the parents' actions are why reunification would be inconsistent with the juvenile's health and safety, there is no material difference between B and D4. And the Court of Appeals did not find that there was a material difference between those two in this case, and no one's argued that. So I think for the purposes of this case, because we're looking at respondents' actions and why that prevents reunification in the next 6 months, this court can collapse these two factors into one inquiry. Or at least the factors, the trial court's findings that address this satisfy both subsections. And those facts specifically are the fact, again, that respondent has failed to plausibly explain the child's injuries. This court already addressed that issue not too long ago in JM, and it found that when there's been an adjudication of abuse, and looking back to DWP, when there's been multiple instances where the child was injured significantly, and the respondent does not explain how that happened, that is conduct inconsistent with the juvenile's health and safety. And again, this is unchallenged at this point, that Liam was in respondent's exclusive care and control for the first month and 2 days of his life, and he was hospitalized after that with broken bones in multiple stages of healing, which means there was multiple separate instances of abuse. In the trial court's 3 previous orders, going back to December of 2021, and this hearing was in August of 2022, in each of the 3 previous hearings, the trial court had noted in its order that it's concerned that respondent had not explained how Liam was injured. DSS, in its report to the trial court in this hearing, says that its concern for reunification was that respondent had not explained how Liam was injured. Again, under JM, that is a fact that goes to conduct inconsistent with the juvenile's health and safety. As well, the other thing we have here is that Liam, as a result of these injuries, has very extensive medical conditions and medical needs. And in the 4 previous orders preceding this case, the trial court had told respondent that she needed to attend his medical appointments so that she could learn how to care for these extensive injuries. And we see on page 183 of the record that respondent had the ability to make video calls. On page 183 of the record, she was able to travel to North Carolina for court hearings. And despite that capability, she did not choose to exercise that to attend a single one of Liam's hearings. And so the trial court found, and again, at this point, it's not challenged, that respondent does not, has not attended his hearings, which were for his appointments, which were for the purpose of familiarizing herself with Liam's extreme medical needs and treatments. And so what you have is you have a failure to explain how Liam was injured, and also an inability to provide the care that he needs because she hasn't learned from his doctors how to take care of him. Those findings, along with the rest of the ones we've noted in our brief, show conduct inconsistent with the juvenile's health and safety. And looking at this court's precedent, the fact that the trial court makes specific factual findings rather than discussing the general statutory language does not mean there's reversible error. Because AKO, that's a opinion from, or sorry, APW, that's an opinion interpreting 906.2, 906.2C specifically about whether reunification efforts of DSS were reasonable. Now, nowhere in that trial court order were there findings talking about using the word efforts, using the word reasonable, or having a similar sort of conclusory statement. Instead, what the trial court did is it said, these are the specific steps that DSS has done. They've gone respondent father, therapy. They've tried to get them set up with parenting classes. There were specific factual findings of DSS's reasonable efforts. But again, that addresses the substance of the statutory factors, which is this court's recognized as far back as 2012 in LMT, is all that a trial court order needs to do to be upheld. And so for these reasons, the trial court order sufficiently addressed the concerns and language of 906.2B and D4, and there is no error under it.
And I guess part of your position is if you try to walk through our case law over the years, we have consistently struggled with what is that final thing you're talking about where we basically, or the trial court takes the specific words that are in the statute and repeats them. Is that a conclusion of law? Is it an ultimate finding? What is that? Is it a mixed question of law, in fact, and so on? But the one thing we know must be in the order are the evidentiary findings that would support that. And I understand your position to be that's what's the most important part, and that's in there. And what the appellate courts do in error correction is you piece together, well, based on those findings, does that support this ultimate finding, this conclusion, whatever you want to call it? Is that your position?
Yes, Your Honor. And again, I think that's been established since LMT. It's demonstrated in APW. It's demonstrated CH, plenty of cases before this court. The next factors that are at issue is 906.2 D2 and D3. And I was reading CH the other day, and I realized that CH already addressed what satisfies 906.2 D2, and it's quite relevant here. What CH looked at is, first of all, specific findings on respondent's compliance with her plan. And the trial court here incorporated the findings of fact in DSS's report on page 283 of its order, paragraph 3. It made a finding that the facts in that report were true and reliable. So based on this court's recent decision in HB, that's what the trial court needs to do to correctly incorporate a DSS report. And then if you look to page 183 of the DSS report, it has everything respondent is doing, both good and bad, in compliance with her plan. She's attending parenting classes. However, she's not attending Liam's medical appointments. And that is what this court looked at in CH to find that D2 was satisfied. We also have in the report, we have the finding, quote, on page 188, social worker Soanes has maintained contact with Ms. Lashley and Mr. Westbury. And that, too, is similar to the findings in CH, which this court found to satisfy D2. Notably, as far as I can tell, in CH, there were no findings in that order specifically mentioning the guardian ad litem. Instead, it mostly discussed the plan and DSS. But this court still found it hit the substance of that factor and it was sufficient. Now, I acknowledge CH did reverse under the third factor D3, which is respondent's continued availability. However, that would be inappropriate here because we have more than we had in CH. Specifically, we have the trial court's, or in the DSS record on 183, discussing both respondent's ability to make phone calls, her ability to make video calls, her ability to travel to multiple court hearings out of state, which shows her continued availability. And we have on pages 185 to 187 a list of all of respondent's contacts in DSS. That is far more than was present in CH, and it satisfies this factor. But if this court were to find that those findings are getting there, but they aren't enough, it should apply the analysis that it's applied in CCG and tracing back as far as even AKO, which is whether that error is material and prejudicial. This court has said when a trial court fails to fully respond to a statutory factor, we don't immediately remand. We first ask whether that error is material and prejudicial. And material and prejudicial means likely to change the outcome of the appeal. Because as LMT recognized, yes, these factors are important. And if it's likely that it can make a difference on remand, then certainly we will remand. But when all that a remand is going to do is delay permanency and not materially change, doesn't have a material chance of changing the outcome, we won't remand for remand's sake. And in this case, remanding for the trial court to make additional findings about respondents' continued availability after the case is over and after it has released DSS and the guardian ad litem is not likely to change the outcome here. It's not a material and prejudicial error. So the final part I'd like to discuss is the Court of Appeals opinion under 903. And in 903, that is looking at whether the trial court's dispositional decision to place Liam with the Halls and to find that it was not in his best interest to be with Mr. Westbury was an error. And if I understand my friend on the other side's argument correctly, and of course I welcome her to correct me if I misunderstand it, but I think she's arguing that the trial court failed to first consider Mr. Westbury as a placement. And the order does not support it because the order says that Major and Mrs. Hall, placement with them is in the child's best interest. And if the trial court had made that determination first, there would have been no reason to make any findings about Mr. Westbury because best, the word best is an exclusive term. There aren't multiple best interests. So the only way for there to be findings about Mr. Westbury in the order is if the trial court first considered him, found that placement with him was not in Liam's best interest, and then considered Major and Mrs. Hall. The reason that the finding about Major and Mrs. Hall comes first is just because my personal theory is the trial court judge paid attention in legal writing class when we were told to put our conclusion first, Crexac, if you will, and so he put the conclusion first. But the fact that he considers the maternal grandfather shows that that consideration came first. And then Respondent has challenged some of those findings of fact. We show in our brief why those findings of fact are supported by the evidence. Specifically, in page 121 of the record, this was 4 months in April of 2022, 4 months before the hearing had occurred, and 2 years into the proceeding. I know Respondent has pointed out that Mr. Westbury did not have any control over Georgia DSS, and we aren't arguing otherwise. But what Mr. Westbury did have control over was his relationship with Liam because he was allowed visitation. And yet on page 121, nearly 4 months before this order is entered, the guardian ad litem reported that Mr. Westbury, quote, has not shown interest in visiting Liam. She further reported that the Halls twice told Mr. Westbury, we can drive to Georgia and bring Liam to visit with you. And Mr. Westbury declined them both times. That was the first 2 years of Liam's life that Mr. Westbury chose not to be involved. And for that is why on page 285, paragraph 8.I, the court discusses why Mr. Westbury is not bonded with Liam. That was not Georgia DSS's fault. Given this situation, when you're dealing with a child who has developmental delays and is in a healthy family, it was within the trial court's discretion to find that it was not in his best interest to be removed from that situation and placed with someone that he did not have a bond with. It's hard enough for a healthy, normal child to be removed from a healthy family and placed with someone else. In addition to that, there's the evidence in the record about Mr. Westbury not putting in the work shadowing Major and Mrs. Hall to learn how to take care of Liam's extensive medical needs. For these reasons, Your Honor, the trial court's order should be affirmed. I will cede the remainder of my time proceeding rebuttal to Mr. Wunsch.
Thank you, counsel.
Mr. Chief Justice, and may it please the court, my name is Matt Wunsch. I'm appellate counsel for the Guardian Ad Litem program, and I represent the juvenile Liam in this case. I don't want to belabor or repeat the points that Mr. Wilson made so ably in his argument. I just want to add the GAL's perspective on these issues. We do agree, with the arguments that the trial courts satisfied its obligations under the statute here to make findings that embrace the substance of those statutes, even if they're not in the exact words of those statutes. And I think to Justice Dietz, to your question, Your Honor, that's what matters. That is the most important thing that a trial court has to do to permit appellate review, for the parties to know that the facts were properly litigated. That's really, I think, at the heart of the issue in this case. And our position is that is what happened here. I wanted to add, and Mr. Wilson talked a little bit about it, I think, at the end of his remarks, but in this case, the guardian ad litem did a very thorough investigation. You can see it in the court reports from the outset, and was consistent in her position that what was in Liam's best interest was placement with the Halls. Had reunification in her recommended plan as a secondary plan early on, but that changed pretty quickly, and she was consistent. You can also see in her court reports, pages 101, 119, and 175 of the record, you can see the list of contacts that she made. She was talking to the foster family, she was talking to the grandfather, she was talking to Liam's treatment specialists. So there was a robust and thorough investigation by the guardian ad litem in arriving at that recommendation, again, that was consistent throughout the case. Also would direct the court to examine the trial court's own questioning of the social worker, which is, it's not unheard of in our cases, but it's a little unusual for after the attorneys have done their questions, then the trial court has its own questions, and it happens from time to time, but not in every case. And you can see the trial court's echoing the same concerns. It's the court that's the judge that's in the courtroom, observing the witnesses, getting to see their demeanor, and it goes through with the social worker. So Mr. Westbury has to work full time. He's not able to provide 24-hour care, right? He hasn't had the experience of caring for Liam and providing for his special needs, right? And his girlfriend is not related, they're not married, she's not related to Liam by blood or marriage, right? So you can see the trial court going through its own concerns with the witness and clarifying that on the record. That is, I believe it's 66 and 67 of the transcript, and then again on 71. So I think that passage is really illuminating to me as to, in conjunction with the findings that the court made, the DSS court report that it adopted and all of the information and facts that are in there, and then the findings of fact that the court made in its order documenting the Hall's exceptional care for Liam, their commitment to caring for him, and then just the lack of commitment from his biological family on the other side of that. And so there's no abuse of discretion in that decision. I believe that the order allows this court and allowed the Court of Appeals to conduct appellate review, that the Court of Appeals took what I would call an overly mechanical approach to the statutes, not consistent with LMT and the cases that Mr. Wilson talked about from this court, that really embrace, reviewing the substance of the order, not just viewing it as, a form document with boxes to be checked. So that's the GAL's position. Again, I don't want to belabor or repeat the same points that Mr. Wilson has already ably made. If the court has no further questions, for me, we just join in asking the court to reverse the Court of Appeals opinion, and we'll reserve the rest of our time for rebuttal.
Thank you, counsel.
Thank you.
We'll hear from the appellee.
Good morning, Chief Justice Newby and Associate Justices. My name is Mercedes Chutt of the Guilford County Bar, and I'm arguing on behalf of the respondent mother. Now, I think there's some very important policy issues raised by this case, and I'm going to start with what I think is the most important one, what I think is most at risk here, and that would be the relative priority placement preference. That clearly our statutes are very, very clear that if a relative is willing and able to provide a safe home, the child should be placed with the relative. And of course, our federal statutes make the same requirement. The Departments of Social Services will not be getting federal funding unless they have statutes that do require that relative or family placement. The public policy of the state is clearly to keep families together, to place a child with a suitable relative when possible. Now, Mr. Westbury is my client's father. And I think one thing that's very, very important, I think, to emphasize is that when you read the briefs of the foster parents, basically, the foster parents emphasize every negative thing about Mr. Westbury that appears in the GAL reports. However, those negative comments and negative descriptions are fully rebutted by the DSS reports. And in every single court order, the trial court found the DSS court report to be credible and reliable and incorporated it as a finding of fact in its orders. It did not give the same treatment to the GAL reports. With every court order, it simply found the GAL reports were received into evidence. And so by asking this court to ignore the DSS reports, which the court found credible, reliable, and incorporated, and instead to focus only on the GAL reports, which completely contradicted the DSS reports, is actually asking this court to ignore the trial court's findings of fact and how it weighed the evidence, and to make new findings of fact. And to address specific things that appear in briefs and appear in the arguments today about Mr. Westbury. So what the evidence shows in incorporated court reports is that Mr. Westbury requested placement of Liam almost immediately after Liam entered the care of the Onslow County Department of Social Services. Liam entered the care of Onslow DSS on, I believe, June 5th. By June 15th, Onslow County DSS had actually sent a home study request to the state of Georgia. Mr. Westbury lives in Waycross, Georgia, and the entire family of the respondent lives in Waycross, Georgia. That consists of her father, her mother, her two brothers, a couple of aunts, and cousins. And in fact, the family has been in that area for quite some time. Mr. Westbury is currently living in the house he grew up in. There's a large community of family members in that area. So Onslow County DSS makes a home study request to Georgia for Mr. Westbury's home within 10 days of the child entering custody. What happened at that point is documented in all the court orders and all the court reports. Basically, it would seem to be just one delay after another, and it wasn't really a priority, I'm assuming, of Ware County, Georgia, or the state of Georgia to do this home study. The first home study request was returned as not being able to comply because Mr. Westbury had been hospitalized for COVID, something that was not within his control, not his fault. Then another home study request was returned again for supposedly lack of communication. And then finally a third one was approved, but not until July the 15th, 2022. So the whole home study process began on June the 15th, 2020, and did not conclude until July the 15th, 2022. And now, as to the lack of communication, the social work supervisor, I'm not sure I'm pronouncing this person's name properly, I think it's Duchalat Pierre, testified that none of this was a problem with Mr. Westbury. None of it, that in fact, Mr. Westbury cooperated as much as he possibly could, that he had stepped up to really help his daughter, that the family came together, that he did everything he could. She even, Ms. Pierre, or Mr. Pierre, even said that, at one point, they had the personal phone number of the director of the Ware County Department, Georgia Department of Social Services, just bugging him. When are you going to get this done? When are you going to get this done? Finally.
One question about, just to clarify what it is that you're arguing. So, the trial court made a finding that Westbury wasn't able to provide the child care that Liam needed. So to support that finding, does it matter if there's any intentionality behind that inability? So, for example, if the court is just looking and saying, well, I'm seeing in the record a lot of times where Westbury isn't even available to respond to a home study. There's a lot of evidence that there's things that come up in his life that may mean he can't focus entirely on Liam, and this is a child that has special needs and really needs this attention. Isn't that competent evidence that would support that finding, or are you saying there needs to be some indication that it was Westbury's fault that these things happened?
No, I'm not saying that. No, actually, that finding, the Court of Appeals held that finding was not supported by the evidence. And there is not evidence in the record to support that finding. Because basically, Mr. Westbury, yes, he did work. He had a full-time job. He had the same job for 12 years at a funeral parlor. He worked, like most of us do. But he also testified that he, could take time off to take Liam to doctor's appointments, that he planned on taking Liam to doctor's appointments. And there was simply no evidence. The Court of Appeals agreed that Mr. Westbury did not have time to take care of the child. And also about Mr. Westbury, it's simply not the case that Mr. Westbury had the opportunity to visit but didn't. If you look at all the court orders, Mr. Westbury was never given the opportunity by court order to visit. And there's nothing in the record that indicates to the contrary. The GAL report does contain, in several of them it says, he had the opportunity to visit but didn't. But there's simply the court did not, there's no evidence the court placed any credibility on that. They found that credible. And there's nothing else in the record that indicates that Mr. Westbury was awarded visits. He wasn't awarded visits by order. I know from working with departments of social services, you can't just show up at a visit and expect to visit. That's not how things work. What finally happened was when the Department of Social Services had planned to place the juvenile in the care of Mr. Westbury from early on in the case. And so that had been the plan. And throughout the orders, you see the court is giving the department the authority to go ahead and place the juvenile with the maternal grandfather if the home study is approved. And so basically, by May of 2022, the social worker arranged for Mr. Westbury and for his fiancée of at least a decade to have a schedule of video calls with the foster parents where they would be learning about Liam's needs, visiting with Liam on the video calls, and sort of shadowing them through video as to how to take care of Liam. And there's no evidence whatsoever in the record that did not occur. They simply, the court report that's incorporated into the final order that's on appeal states that basically it just simply states that they did occur, but it doesn't really go through. It doesn't say any of them were missed. So so Mr. Westbury had been ready, willing, and able the entire time. The GAL did not want the juvenile placed with Mr. Westbury. You can see that early on in the case. There are comments in the GAL report to the effect that the maternal family just doesn't have the capacity to understand Liam's needs because some of the relatives told the GAL that maybe Liam was just slow, like they were cousins. And there is this elitist thread running through this, that, the respondent's family, lives in rural Georgia. They're not wealthy people, and they didn't go to college. On the other hand, that contrasts significantly with the foster parents. The foster parents, have a good income. Foster father is an officer in the Marine Corps. Obviously, he has a college degree if he is. It's a different socioeconomic situation. And I think this is extremely important. I mean, when you look at what departments of social services have to do, departments of social services have to follow the law. And the law right now requires, family placement as a preference. The government cannot get involved in determining which home is better based on socioeconomic factors. That is just, and departments of social services simply can't do that. If the home is a safe home and the relative is willing and able to provide appropriate care and safe home per statute, 7B903, the juvenile should be placed there. Now, in terms of the only findings the court made, and this is the Court of Appeals held that the trial court simply did not follow the statute, did not apply the proper statutory analysis, because it seemed to start off with like a side-by-side comparison of the families. And that's, and the Court of Appeals pointed out correctly, that's how, if you do that, then we don't have a relative preference. That, is basically abrogation of the relative preference. I mean, I think you can always find a family that maybe on paper is better, depending on what your view of better is. This wealthier, this more educated, that has more resources. But that's not what the statute requires. The statute wants to keep families together. And, that's federal and state. And that's extremely important public policy of the state. And I'm concerned that this case could have the effect of certainly mitigating that, lessening that. And that would have the effect of making it very difficult for departments of social services and trial courts to function. But the findings there, I'd argue they just simply aren't adequate, because like the Court of Appeals said, the trial court has to first determine if the foster parent is willing and able to provide a safe home. And notably, when we're talking about the fiancée girlfriend, Ms. King is her name, she was part of the home study. She was approved. The home study checked her out as well as Mr. Westbury. There was always a plan that she would be providing care during the day for the child. She quit her job or retired from her job to do that. That was her plan. They were that dedicated to the child. The home study, so she went through the whole home study like everyone else. She went through fingerprints, made her medical records available, participated in interviews. And the home study approved her, or approved the home with her in it as a safe home. That finding was actually incorporated into the court order. It's on appeal. So I would argue that's inconsistent with some of the other findings that indicate, oh, she's just a living girlfriend. Well, yes, she's a girlfriend that lives with him. It's a long-term relationship. And there's nothing about that finding that shows why it is not in Leland's best interest to place him with the Westburys. Now, also, I guess the only thing you have here is the bond. And I'm not minimizing the bond. I mean, I'm sure that child is very bonded with the foster parents. I'm not minimizing that one bit. However, if you only look at bond with a best interest analysis as to whether or not to place a juvenile in a relative home, then that is going to, I think, most judicially abrogate that relative priority as by statute. Because when you take a young child, put them in a home, especially at birth, they're going to bond with the foster parents. I mean, they are. They're clearly going to bond. But that doesn't mean they can't bond with a family, the actual biological relatives. And my argument is that should not be a reason not to move the child. So I would just encourage the court, respectfully, to look at the DSS court reports and how they portray Mr. Westbury and Ms. King and their commitment to this child. Because the GAL court reports are very, very different. Take a very different approach. And so moving on to the mom and whether or not the trial court made appropriate findings to cease reunification efforts. So first of all, when the case came on for permanency planning hearing on August the 2nd, 2022, reunification was still part of the permanent plan for the child. So what Mr. Wilson just told you about reunification being eliminated before that is not accurate. Until, I believe, June of 2022, reunification had been the primary plan, and custody with a court-approved caretaker or guardian had been the secondary, concurrent plan. I believe it was June of 2022 that was changed to custody as a primary plan, and reunification is still a concurrent plan. So when the court placed custody in the halls, it ceased reunification efforts. And there are tons of cases that say that. It's well established. Basically, if the court order, terminates, if the effect of it is to terminate reunification efforts, it is an order ceasing reunification efforts, and has to comply with the statute on ceasing reunification efforts. In this case, the order does not mention reunification efforts at all, and it doesn't make what I would call an ultimate finding or conclusion about that. And I don't even know what to make of that. However, our case law is very, very clear that the evidentiary findings have to meet the statute's concerns. LMT, for example, says this. The statute's concern is, are reunification efforts, further reunification efforts futile? And, is the parent acting contrary to the safety and health of the child? And that is actually essentially the language of 7B 602B. Does the evidence clearly show? Does the evidence show that reunification efforts would be clearly unsuccessful, or the parent is acting contrary to the health and safety of the juvenile? So what we have here is an order that only focuses on, and I'm not minimizing this, the injuries that child suffered were extremely severe, no doubt about that. But it focuses on the injuries, and it focuses on the mother's failure to explain, and it focuses on the non-attendance at the medical appointments and her pending felony charges. Okay, so importantly about the mother's failure to explain, that is not synonymous with failure to take responsibility. So the cases I think that the foster parents are citing, basically, which would be GWP, which is a case out of Guilford County that I'm very familiar with, and also JM. Those are cases where it is very clear that parent is just not going to accept that there was physical abuse. It just didn't happen. GWP, the parent kept on maintaining that the physical abuse was caused by the dog, and that it was caused by some sort of medical mystery that no one could figure out. JM, the mom just simply, emphatically said that, oh, Dad couldn't have done it, or Dad wouldn't do that again. Well, there's no basis for that. There is no acceptance in those cases that the child had been injured intentionally. There's no question here that the medical evidence shows that the injuries the child received were not the result of accident, and that can't be disputed. And there's also, it can't be disputed that the only people that the child was in the exclusive custody and care of only my client and her husband. But it does not make my client exclusively responsible, and it does not mean that she is not accepting responsibility for it. At the time of this hearing, she did have a pending felony charge that had arisen out of the events that brought the child into care, all those terrible injuries. It did not occur after the case plan started. Her charge was felony abuse for failure to, felony medical neglect for not taking the child to the hospital. It's a felony. The father, on the other hand, was charged with that felony medical neglect, as well as intentional child abuse, 4 counts of it. The mother, in this case, my client, was able to postpone very quickly, and she was allowed to go to the state of Georgia by the department, as I read the record. And now her charges are cleared, and she's finished with everything. The father, however, is still in prison. And so, at the time of this hearing, however, the charges were pending. I mean, any criminal defense attorney is going to say, don't waive your Fifth Amendment privilege by talking about what happened. So we don't really know if she's not taking responsibility. I mean, I guess that could be true, but there's nothing, but just the fact of mere failure to explain, under those circumstances, which you have pending criminal cases, you don't want to waive your Fifth Amendment privilege. Failure to explain does not mean failure to accept responsibility in the same manner as GWP and JM. And I think one of the biggest problems.
What's the evidence that she did take responsibility?
There's actually, the evidence I think that it would be indirect. that she went back to Georgia. She got her life in order. She had completed her case plan in Georgia. And that's in the court report, the DSS court report that was incorporated into this court's order that's on appeal. And that she had a second child that she was pregnant with when she left the state of North Carolina. That she gave birth to that child in March of 2021. The child was removed by the state of Georgia because of pending felony charges. By the time of this permanency planning hearing, she had that child back. And the child has been completely returned to her by now. And in fact, the child was returned to her by the permanency planning hearing. The child had been placed back in her home. And at that point in time, Georgia was just going to supervise how she was doing. But she had complied with everything Georgia had asked, and she had complied with just about everything North Carolina had asked, except driving, and I think it's a 7-hour drive from Waycross, Georgia to the coast, basically Jacksonville, North Carolina. It's about 7 hours according to my MapQuest. So she's a person with limited means, and she had to have a job under her Georgia case plan, her North Carolina case plan, and the child had 6 medical appointments a week. Well, therapy appointments, like occupational therapy, physical therapy, not necessarily medical. And really, I mean, it's all through the court report. It was not really possible for her to attend those appointments in person after she moved to Georgia. And you're not going to find a place in the court's order where the court ever said, you know, ma'am, you need to get back here if you want to reunite with the child. You don't need to be living in Georgia. You need to be here, and you need to be participating in these appointments. That is not there. So it's almost like a tacit approval of moving to Georgia. So I would argue that, to answer your question, that what she did to show that she's going to provide a safe home is really turn her life around. She's not with her husband anymore. She goes by Westbury as her last name, and you know there's no indication that she doesn't take responsibility. But was she ever, you know, examined under oath as to do you take responsibility at that point in time? No, she wasn't. And I do believe it's because of the pending criminal charges and not waiving her Fifth Amendment privilege. Now, you have and I think one of the things about the foster parents' argument that I think is a little bit confusing is it just sort of misses the woods to the trees. So what the trial court has to enter enough evidentiary findings for a reviewing court to look at it and say, okay, you know, the trial court has with these findings established that this parent, further reunification efforts will be futile, or that this parent is not acting consistently with the health and safety of the child. That's an ultimate finding.
Counselor, you keep using the word futile. It's my understanding that the North Carolina General Assembly changed that language. You may be referring to a prior case. Can you help me understand that? Right.
Futile is in LMT. That's the case that first said, you know, that talked about what sort of findings you're supposed to have. And it no longer says futile. It says that you have to find that the findings have to show that reunification efforts would clearly be unsuccessful.
That's the language in the statute now.
Right. And to me, that's sort of, I view them as synonymous. Well, maybe they're not, but
I can see that. But for the General Assembly to take action to change the words, I think does have some significance.
Absolutely.
In this case.
And I'm just simply quoting LMT there, which has actually been quoted many times, but clearly unsuccessful. But how's the court? So what you have here is an order that incorporates the court report that finds that the court report states that incorporates the court report the findings of fact. The court report states that the child can be returned within 6 months. So it's not the case that there was no evidence of that. No, that was in the court report, and that became a finding of fact. Can be returned in 6 months. That there would be no grounds to terminate parental rights. Actually, that means that no lack of fitness, no neglect, no willful failure to make progress. The DSS did not recommend returning Liam within 6 months because of the mother's pending felony charges and failure to explain. But nothing in that court report can be interpreted to mean that further reunification efforts would be clearly unsuccessful or contrary to Liam's health and safety. So if anything, it just creates a really contradictory order. The Court of Appeals did not focus on the fact that the DSS report was incorporated. It just looked at the findings that were there, which is not attending medical appointments, and the pending felony case, and then the failure to explain. and found that they were insufficient. And I would agree with the Court of Appeals. I don't think that gets you logically. I mean, all you have to do is enter enough findings, from what I understand, to reasonably support that ultimate determination that, reunification efforts would be clearly unsuccessful or inconsistent with the juvenile's health and safety. And I just don't think you can get there with those findings. And I think a further complication that the order itself is just very, very inconsistent, because when you have the court report incorporated, and then you have the findings the court made, I don't even know how you can make them. I don't know how they can be viewed in a coherent manner. I cannot think of a way. I know this court has ignored inconsistent findings. This is beyond inconsistent findings. It's like an inconsistent outlook, and I don't know how that can be reconciled. As the relevancy issue, I think I argued that in my brief. I mean, I don't, whether or not you want to apply, the only place you can apply a relevancy test is 906.1, which states the trial court shall make findings that are relevant. And I think there's no argument that whether the juvenile can return home in 6 months is not relevant, because it was addressed by the Department of Social Services, and it was incorporated into the court's order. So I don't think that argument really goes anywhere. I do think that what's going on here with some of the arguments is that the foster parents are not understanding that when you look at whether or not the findings as a whole meet the statute's concerns, that's a de novo review. And so it's not a de novo review is a question of law, and there is no deference to the trial court with de novo review. This court has made that clear. It's a relatively recent case on that, and that's just not the case. There's not a deference with de novo review. So I mean, my argument here is that basically, that I think the Court of Appeals was correct in seeking to remand this order for clarification, more findings, to see if it can be reconciled. And let me see. There were some things I just wanted to, let's say 1 minute. Frankly, I mean, I think there's some misstatements of fact. I'm not going to go through them, but the order is a little bit misconstrued about what the court did order and didn't order. Again, the court did not say that my client failed to accept responsibility. The finding was failed to explain. And, the same with the foster parents, Mr. Westbury, there really was no finding that he didn't visit or that he did not know how to meet the child's medical needs. The finding was, I mean, just the findings was that the foster parents would be able to do it better. But I don't think that is supported by the evidence. And that was argued at the Court of Appeals and not waived. I think it'll take the foster parents a period of time to learn Liam's needs firsthand. They've been attending appointments. They've been attending video calls. They've been shadowing the foster parents through video calls. They have found medical providers for the child. And I think they understand on paper the medical needs of the child. That's not the same as taking care of the child day to day, and I understand that. But I think they need to be given the chance. There's no reason why they cannot do what Mrs. Hall did and learn how to take care of this child and meet his medical needs. Thank you.
Thank you, counsel. Rebuttal.
May it please the court. A couple quick points on rebuttal. Let's start with, how is the DSS report incorporated if it disagrees with the trial court's recommendations? The DSS report was incorporated for findings of fact. And this court knows there's a difference between findings of fact and recommendations. Recommendations aren't fact. A fact is a specific occurrence in place and time. So on page 186 of the record, it has the DSS report where it reports that on June 27th, 2022, Respondent and DSS had a phone call. That is a fact. That's something that happened in place and time. That's the part of the DSS report that the trial court on page 283, paragraph 3, incorporated. It clearly did not incorporate its recommendations, just the facts, specific occurrences in place and time. And let's talk about the facts, because when the trial court makes a finding, we look at the facts to see if it supports the trial court's finding. The trial court finding, again, on page 285 of the record, paragraph 8.I, is that the child has not had significant regular contact with Mr. Westbury or Miss King sufficient to form a close bond with them. What evidence supports that? Well, let's start again with page 121 of the record. And again, if you see on trial page 136, the trial court reviewed the record in making this order. Under CCG, the trial court considered any and all evidence. So what evidence was the trial court considering? Quote, Mr. Westbury has only met Liam once a year ago and has not shown interest in visiting him since. This is 2 years into the juvenile proceeding. He is allowed to FaceTime with Liam, but does so only sparingly. Mr. Westbury's girlfriend will likely be Liam's primary caretaker. She has never met Liam. The foster family proposed stopping by their home while on their way to Florida on vacation twice so that they, meaning Mr. Westbury and the girlfriend, could meet Liam and assess his condition, but Mr. Westbury declined both times. This is not about socioeconomic status. Mr. Westbury had the opportunity to bond with Liam, and he did not take advantage of it for the first 2 years of this case, and that is why Liam is so closely bonded with the Halls. And that's not getting into the other evidence in the record about how Mr. Westbury has not taken the opportunity to shadow Mrs. Hall to learn how to take care of, again, Liam's extensive needs. There's more evidence in the record, quote, Liam, this is 178, Liam's therapists agree that if Liam is removed from his foster family, his condition will severely deteriorate. All the statute requires to comply with federal law is that the parental placement or the familial placement be considered first. It was considered. The trial court made a finding that Mr. Westbury is not able to take care of Liam. That finding is supported by the evidence. Irregardless what the statute says, again, this complies with federal law, is that if placement with the family member is not in the child's best interest, even if he is able to take care of the child, you still don't place the child there. That best interest determination is reviewed for abuse of discretion. The findings of fact are reviewed for the evidence in the record. The evidence in the record supports the findings and supports that best interest determination. I'd like to go on to the portions of the other factors. And I want to clarify, I hope I didn't misspeak and say reunification was eliminated in a prior order. If I did, I apologize. What happened was in the previous order, the permanent plan was changed so that the primary permanent plan was custody with the court-approved caretaker. The reason for that, as explained in that order and in the 2 previous orders, was that respondent had not explained how Liam was injured. Now, if I recall correctly, I know I never saw this in the trial court. I don't remember seeing it in the Court of Appeals. Respondent raised her Fifth Amendment rights. If that was raised for the first time in oral argument today, basic appellate case law says you can't raise constitutional rights and constitutional issues for the first time on appeal. And I never saw that in the trial court record. And then also, to the extent respondent is trying to relitigate the issue about not attending Liam's medical appointments, again, there's evidence that she was able to participate in video calls, but she didn't video call into these medical appointments. Clearly, it would have been a tremendous hassle for her to attend all of them, but she didn't attend one of them. After 4 previous orders, starting with the abuse and neglect adjudication, and through each of the following permanency planning orders, the trial court told her, you need to attend Liam's medical appointments so that you can understand his injuries and how to take care of him. And respondent did not attend one of them, and the Court of Appeals affirmed, and respondent did not appeal from the fact that that supported the determination that respondent acted inconsistent with her constitutionally protected status as a parent. The last thing I want to say is a quick clarification on LMT, because this court made clear in JM, to the extent LMT was discussing futility, that's no longer law, that's no longer good law, and it disclaimed that. But I don't think, and I think it'd be incorrect to interpret JM as disclaiming the portion of LMT which held that the when looking at whether the trial court order complies with these statutory factors, you look to the substance. And these factors, quote, are to be applied practically so that the best interests of the child, the polar star in controversies over child neglect and custody, are the paramount concern. As my friend on the other side recognized, part of the LMT analysis was looking at a prior statute which mentioned conduct inconsistent with the juvenile's health and safety. There wasn't an ultimate finding in LMT, and said there were specific factual findings that the respondent was falling back into a drug addiction and was taking actions of domestic violence. That's actions inconsistent with the juvenile's health and safety. It satisfied that standard in LMT. The findings of fact in this trial court's order also show conduct inconsistent with the juvenile's health and safety. Liam will be spending the rest of his life with severe medical issues that require constant attention, and the trial court's findings that respondent does not understand how to provide that care. For all these reasons, and for the reasons stated in our briefs, we ask this court to affirm the trial court's decision. Thank you, Your Honors.
Thank you, counsel. Thank you both. Mr. Polk.
All right.